Imagine this for a second. You've been promised a really important new job, gone through all the steps, you're confirmed, all set to start. But then a new boss takes over. And suddenly, the crucial paperwork, your official job commission, it just kind of vanishes. What do you do? I mean, who do you turn to when something that's clearly yours is being withheld? It sounds, well, like a modern HR nightmare, maybe. But for William Marbury, way back in the early days of the U.S., this exact situation blew up into one of the most foundational Supreme Court cases ever. Today, we're taking a deep dive into Marbury v. Madison. And this wasn't just about some missing paperwork, was it?
No, not at all. It was really a profound showdown. It fundamentally shaped, the whole balance of power in American government.
And to help us unpack this, you've given us some amazing source material excerpts from the original court documents, the final opinion itself. So what's our mission today as we dive into these?
Well, our mission is to really dissect this crucial case. We need to trace the argument, see how this seemingly small administrative issue ended up setting this huge legal precedent, get ready for some surprising twists, I think, and a real aha moment about how our government actually works.
Okay, let's set the scene then. The main player, William Marbury. And he wasn't alone, right? There were others.
That's right. People like Dennis Ramsay, Robert Townsend, William Harper, they'd all been nominated by Mr. Adams, the late president, as the documents say, and confirmed by the Senate. They were set to be justices of the peace for the District of Columbia. These were significant jobs appointed right at the end of Adams's term.
Okay, so they're appointed, confirmed. Sounds done. But what was the hitch?
The hitch was delivery. Their commissions were signed by President Adams, yes, and sealed with the official U.S. seal. That sounds final, doesn't it?
It really does.
But for reasons that became, well, the whole point of the case, they were never actually handed over. Then Thomas Jefferson wins the presidency. His Secretary of State, James Madison, takes office. And Madison gets this formal request from Marbury and the others, hey, where are our commissions? And Madison, he just doesn't comply, doesn't hand them over.
So Marbury and his group, they decide to fight back. They get Charles Lee, who was actually the former Attorney General, quite a big name.
Right.
And they go straight to the top, to the Supreme Court. They ask for something called a mandamus. What exactly is that?
A mandamus is basically a court order. It commands a government official to do their job, to perform a specific duty they're legally required to do. In this case, deliver the commissions.
Was that a normal move? Going straight to the Supreme Court like that?
It was definitely bold. You're bypassing lower courts. And it hit a snag pretty quickly during the investigation, Cons.
What happened?
Well, getting evidence was tough. The clerks, people like Jacob Wagner, Daniel Brent, even the acting attorney general, a Mr. Lincoln, they were hesitant. They didn't want to testify about official business, claimed it was, confidential.
But the court pushed back on that.
Oh, absolutely. The court basically said, look, facts like whether commissions exist in the office, that's not some state secret. They actually declared these were facts which all the world have a right to know. Strong words.
That really is a statement. The court's showing it won't be easily sidelined, even with a new administration in power. Pretty gutsy for a young court system, wasn't it?
Undeniably. Chief Justice Marshall and the court were signaling they intended to assert their authority even against the executive branch. A risky move, for sure.
Okay, so the stage is set. Marbury wants his job, Madison won't deliver the commission, and the Supreme Court is involved. Now, the court, led by Marshall, didn't just make a snap decision.
No, not at all. What's fascinating is how methodical they were. They broke the whole problem down into 3 key questions. It's like a roadmap for their logic.
A masterclass in judicial reasoning, really. So what were those 3 big questions?
Okay, first, did William Marbury actually have a legal right to the commission he was demanding? Was it truly his?
Right, step 1.
Second, if he does have that right, and clearly that right has been violated because he doesn't have the commission, do the laws of the country actually provide him a remedy? Is there something he can do about it legally?
Makes sense. A right isn't much use without a remedy.
Exactly. And third, the crucial one. If there is a remedy, is that remedy a mandamus coming directly from this court, the Supreme Court? Can we issue the order?
Okay, 3 big questions. Let's dive into number 1. Did Marbury actually have a right to the commission? How did the court figure that out? They looked closely at the whole appointment process, didn't they?
They did. They dissected it. They identified 3 distinct steps. First, the nomination. That's purely the president's decision.
Okay.
Second, the appointment itself. That also involves the president, but it needs the advice and consent of the Senate. Still a voluntary act by the president.
Got it. Nomination, then appointment with Senate approval.
And third, the commission. The Constitution says the president shall commission officers. The court saw this shall as more of a duty, less of a choice, once the appointment is made. And crucially, they separated the act of appointing from the physical piece of paper, the commission.
So when did the court decide the appointment was actually final? Like, when did Marbury's right officially kick in? Was it the signature, the seal, delivery?
This was the absolute key finding for question 1. The court decided the appointment is legally complete the moment the president performs his last required act. And what's that last act? His signature on the commission.
Ah, the signature.
Yes. The signature excludes the idea of its being an coate and incomplete transaction. Once signed, it's done. The president's role in the appointment is finished. The right to the office vests at that point.
So what about the Secretary of State then, Madison? If Adams signed it, what was Madison's role supposed to be? Just stick on the seal and send it out?
Precisely. Once the president signed, the Secretary of State's tasks, affixing the seal, recording it, these were classified as ministerial duties, meaning they are prescribed by law and not to be guided by the will of the president. He wasn't supposed to exercise his own judgment. He was acting under the authority of law, a legal obligation.
So Madison didn't really have discretion to just not do it.
According to the court's logic here, no.
And the court also said actually handing Marbury the paper wasn't the deciding factor either.
Exactly right. Physical delivery, not necessary for the appointment to be valid. Acceptance by Marbury, also not necessary. The commission document itself is just evidence of the appointment that already happened when it was signed. They even said a copy from the official record is legally equal to the original.
Wow. Okay. So, wrapping up question 1, the court says Marbury's appointment was complete when Adams signed and the seal was affixed. And since the job had a fixed term, 5 years, it wasn't something the new president could just undo.
Correct. The court concluded the appointment was not revocable, but vested in the officer legal rights, which are protected by the laws of his country.
Therefore, withholding that commission
Was not warranted by law, but violative of a vested legal right. Clear violation.
Okay, so Marbury has a right, and it's been violated. That leads straight into question 2. Do the laws offer him a remedy? Does the system provide a fix?
Yes, and this really gets to the core philosophy of the legal system they were building. Is it a government of laws, or just, powerful people doing what they want?
A fundamental question. Can you even have a right if there's no way to enforce it?
That's exactly what the court addressed. They leaned on established legal principles, citing Blackstone that every right, when withheld, must have a remedy, and every injury its proper redress. And they stated, quite powerfully, that the U.S. government is emphatically termed a government of laws and not of men, meaning the law has to provide answers.
But they also made a really important distinction here about what kind of acts the courts could actually review, didn't they? The difference between political and ministerial acts.
Yes, absolutely crucial distinction. They separated acts into 2 categories. First, political or discretionary acts. These are areas where the president or his cabinet officers have leeway, judgment calls. For those, the court said, the executive is accountable only to his country in his political character and to his own conscience.
Meaning courts stay out. You deal with those through politics, elections, maybe impeachment, but not lawsuits.
Exactly. But then there are ministerial acts. These are different. These involve a specific duty assigned by law where individual rights depend on that duty being performed. In those cases, the official is acting as an officer of the law, answerable to the courts, and cannot at his discretion sport away the vested rights of others.
And for Marbury's commission, which category did withholding it fall into?
Clearly ministerial, according to the court. Delivering the commission, once signed and sealed, wasn't a political judgment call for Madison. It was a specific duty assigned by law related to Marbury's individual right.
So the answer to question 2 is a definite yes. Marbury has a right. It was violated, and the laws do provide a remedy for that violation. He should have legal recourse.
Right, which brings us logically to the third and, the game-changing question. Is the specific remedy he's asking for a mandamus something that this specific court, the Supreme Court, can issue in this case?
Okay. The court agreed that, generally speaking, a mandamus is the right type of remedy for this situation, commanding an official to do a specific legal duty.
Yes, they confirmed that. And they also clarified that it could theoretically be directed at someone as high up as the Secretary of State. It's about the nature of the act ministerial, not the rank of the person. If it's a legal duty, the rank doesn't shield them from a mandamus.
So far, so good for Marbury. It seems like he's got the right, the violation, the remedy type. What goes wrong?
Ah, here comes the twist. The moment that makes this case so famous. The court looks at the law Marbury's lawyer, Lee, is using to justify asking them for the mandamus. That law is the Judiciary Act of 1789. And that act did seem to explicitly give the Supreme Court the power to issue writs of mandamus directly to federal officials.
So the law passed by Congress seems to say, yes, Supreme Court, you can issue this order.
It appears to, yes. But then Chief Justice Marshall leads the court to compare that act of Congress with the Constitution itself.
Article 3, Section 2, right? The part that defines the Supreme Court's jurisdiction.
Exactly. And the Constitution says the Supreme Court has original jurisdiction, meaning cases that start there only in very specific instances.
Right.
Cases involving ambassadors or when a state is a party.
And all other cases.
In all other cases, the Constitution says the Supreme Court has appellate jurisdiction, meaning it hears appeals from lower courts. It doesn't start the case.
In Marbury's case, asking for a mandamus, that's original jurisdiction, isn't it? Starting a new case right there.
Precisely. It doesn't involve an ambassador. It doesn't involve a state as a party. So under the Constitution, it seems like a case that should have started in a lower court, not the Supreme Court.
So you have a direct clash.
Yeah.
Congress passed a law saying the court can hear this type of case originally. But the Constitution seems to say it can't.
That's the conflict. And the court reasoned, if Congress can just change the Supreme Court's original jurisdiction whenever it wants, what's the point of the Constitution even listing it? Marshall wrote that if Congress could do that, the constitutional division of powers would be form without substance, just mere surplusage, entirely without meaning.
This is where Marshall makes his big move, defining the court's role.
Absolutely. He declares this fundamental principle, that the people have an original right to establish such principles as shall most conduce to their own happiness. That's the Constitution. And that Constitution is a superior paramount law, unchangeable by ordinary means, like an act of Congress. Therefore, a legislative act contrary to the Constitution is not law. Boom.
That's the core of it.
And then he defines the judiciary's role in upholding that. It is emphatically the province and duty of the judicial department to say what the law is. If a law passed by Congress clashes with the Constitution, the courts must choose the Constitution. This is of the very essence of judicial duty. Judges swear an oath to the Constitution, they can't ignore it.
So the stunning conclusion to question 3 is, because that part of the Judiciary Act of 1789 tried to give the Supreme Court original jurisdiction for mandamus in cases like Marbury's, something the Constitution didn't allow.
That part of the Judiciary Act was not warranted by the Constitution, and therefore it was unconstitutional and void.
Yeah.
Invalid.
Which meant the Supreme Court actually couldn't issue the mandamus Marbury wanted.
Exactly. They lacked the constitutional authority to grant the specific remedy requested in that court.
Wow. So the outcome for William Marbury himself is incredibly ironic, isn't it?
Deeply ironic. The court says, yes, you have a clear legal right. Yes, that right was violated. Yes, the law provides a remedy. But we, the Supreme Court, cannot give you that remedy in this specific proceeding because the law allowing you to come directly to us conflicts with the Constitution. So Marbury loses his case. He doesn't get the commission via this route.
He lost the battle. But the war, in terms of legal principle, went somewhere else entirely.
Precisely. Because in the act of denying itself this specific power given by Congress, the Supreme Court established something far bigger.
Judicial review.
Judicial review. For the first time, the court definitively asserted its power to declare an act of Congress unconstitutional if it conflicts with the Constitution. It established the Constitution as the supreme law of the land, above even Congress, and positioned the judiciary as the interpreter of that supreme law, a precedent that fundamentally shapes American law even today.
It's incredible when you think about it. Relatively small fight over a few justice of the peace jobs.
Right. Seems minor on the surface.
Escalates into this monumental ruling that defines the power dynamics of the entire government. This deep dive really shows how those foundational moments happen.
It really does. Small sparks, huge consequences for the structure of government.
So here's something to think about. A final provocative thought for you listening. The court, by refusing power, in this specific instance, the power to issue the mandamus via original jurisdiction, paradoxically claimed a much greater power, the power of judicial review. What does that tell you about the, maybe, strategic genius of Chief Justice Marshall? Or was it just the inevitable logic of having a written constitution? And how does that decision born from a lost commission continue to echo in the balance of power between Congress and the courts right up to the present day?